I'm the Texas MDL asbestos judge, multi-district litigation. I am now convinced that the Texas MDL was created by our legislature with the intent that it be the death knell of mass torts, that it be a way to shut it down. I think our legislature was looking at the federal asbestos MDL as a model when they enacted the MDL statute. Well, the first thing I did in trying to organize the Texas MDL asbestos system in 2004 was to reject everything that the federal MDL was. And I did that after talking to a couple federal judges who say, I send a file like this off to the federal MDL and it comes back 9 years later an inch tall. And I said, well, that's no system at all. I said, what kind of rulings do they make up there? And he says, I don't see any rulings. I don't see that anything was done except for annual settlement conferences. And I decided that wasn't the system that I was going to model the Texas MDL after. I inherited 85,000 cases in 2005 when the legislature made this system retroactive. I was told there were 3 asbestos cases. We hear there's another 17. And in another year, it might go to 700. 2 years later, it was at 85,000. But 83,000 of those are inactive cases that the legislature prohibited any discovery, any motions, and perhaps even attorneys' withdrawal from those cases. I mean, they're in what we call the deep freeze. So what I did in setting up the Texas system was not go with FIFO, not go with plaintiffs with selecting dockets. I used the law of economics. I know Senators Paul Simon and Phil Gramm, or former Senators Paul Simon and Phil Gramm, both take credit for the quote, Congress can pass whatever laws it wants, but we can't repeal or amend the laws of economics. What I did was decide that any case that the plaintiff's lawyer was interested in making an upfront investment in would be given priority on the docket. And we call those fast track cases. And if the plaintiff's lawyer is willing to produce to all defendants all medical records of a plaintiff and all employment records of the plaintiff, they get a trial in 4 months. You don't have to prove to me that your client's about to die. Produce those records up front at your expense and you get a trial in 4 months. It's an incredibly simple system, and it was designed to address the complaint I heard on the creation of the MDL in Texas that we have dying plaintiffs and we need to get these cases to trial. The result is that cases move. The second thing unique about the Texas system is that I, as asbestos judge, will never see a jury. All I do is all pretrial motions. Now, when I say all pretrial motions, that's summary judgments, special appearances challenging jurisdiction, venue motions, and it does make a difference in Texas whether your case goes to trial in Brownsville in the deep Rio Grande Valley or Kerrville, which is a plaintiff's hellhole. Not a defendant's hellhole, it's a plaintiff's hellhole. Kerrville is. Brownsville might be considered the reverse. In any event, I'm also required, as I read the rule, to go through all motions in limine, to receive all documents into evidence, to go through all video deposition excerpts and make rulings. The effect of all this is that the documents that come into trial in one case are the same documents that are going to come into trial in another case against the same defendant. And assuming I can remember what I do from one case to the next, and hopefully I do, rulings are more or less uniform. Lawyers know 6 months in advance, they know before they file their case which documents are going to be coming into evidence. The other thing unique about the Texas experience is I don't ever see the jury. In fact, once I handle all these motions, once I go through all the exhibits, once I go through the video deposition excerpts, I remand the case to the court in the county from which it came and where it stayed usually 2 or 3 days before it gets brought to Houston. And I never see the case again. In fact, I found out this morning that a case that I heard that I did all the pretrial on, taking a couple days, a month and a half ago, settled after a week in trial. Nobody ever tells me when cases settle. Fine, not my job. Nobody ever tells me when verdicts are received. Fine, not my job. My job is to do everything up to pretrial and then I wash my hands of it, and it's not my job anymore. A lot of my job is therefore administering cases, administering the docket, and every Friday every Friday we set between 150 and 200 substantive motions, discovery motions, summary judgment motions. And that's what I do week in and week out. I'll tell you, whatever system is adopted in any state, in any locality, you always have to be aware of the law of Moses. Now, I'm not talking Moses who parted the Red Sea. I'm talking Robert Moses. You know who Robert Moses is. He was the Road and Bridge Commissioner for the city of New York. And what he learned is the wider you build highways, the more traffic the highways get, the more subdivisions that are built out there. Therefore, the more traffic gets built, you have to build a wider highway, and you keep building wider and wider highways. And no matter how wide you make them, there's going to be more traffic that comes down those highways. No matter how efficient any system is, the more efficient you make it, the more traffic you're going to get, and the less efficient it's going to come. And that is the law of Moses. And it cannot be changed, and it's a law of economics. So make your system efficient, and all it's going to mean is you get more work.